So this is our legal and legislative segment where we tell you what you need to know about all the current lawsuits in action. But remember, neither Mike or I are lawyers. We cannot give legal advice. If you are in need of legal advice, we have a great resource for you. Our friend John Dillon is a lawyer, and John has been helping more and more people fight those GVROs. And if you're not aware what that is, those are gun violence restraining orders. And, if you or somebody you know has a need, give John a call for anything gun rights and or law related. His website is dillonlawgp.com, and his phone number is 760-642-7150.
Okay, I'm pulling up a couple of things here. And one of them is the Barba case, Barba versus Bonta. The Barba case had to do with, it was the privacy case that happened. I don't know if everybody remembers, but the Barba versus Bonta lawsuit has to do with privacy of information for gun owners, and it came about after California voted to break the trust of gun owners by providing their database of information on gun owners to third parties, which, of course, you're probably asking, why is there a database, number one? Number two, why are they providing that database to anybody, let alone, a non-government entity? They want universities to use your information to think up more ways to infringe on your rights using studies that appear to be academic and appear to be science, but aren't. So what our attorneys did, and what if you're a San Diego County gun owners member, if you're an Inland Empire gun owners member, if you are a Orange County gun owners member, then you are a plaintiff in this case, because we're all plaintiffs. And then, of course, Barba, the named plaintiff, is she's actually a resident here. I think she lives down in she lives in. Let's just say it's a lawsuit about privacy. So let's not give her exact address, Mike. But she's here in San Diego, and I just wanted to read the declaration. We gave a declaration for a summary judgment. Now, if you look on our lawsuit website, if you go to stcgo.org/lawsuits. You'll pull up a guide of terminology that will tell you exactly what a summary judgment is. But essentially what a summary judgment is it's a statement saying, look, here are the general facts. Here's what's going on in this case. We think this case is so obvious that we shouldn't have to go through a complete formal argument. So if you could just make a judgment right now. So let me see. Let me read you just a part of this. So it talks about what IEGO is, what SDCGO is, what OCGO is, and that I'm the founder of all three, and here are the generally why we exist and what the who members are. And then here's a section of the summary judgment. I've completed multiple firearm and ammunition transactions through a firearms dealership in California since 2020. Accordingly, my personal identifying information is contained in the California Department of Justice's automated firearm system and its ammunition purchase records file, meaning they have a bunch of information on me. I've completed multiple firearms ammunition transactions through a firearms dealer in California since 2020. In the course of filling out the paperwork required in those transactions, I had to provide my personal identifying information, including my driver's license number, home address, telephone number, date and place of birth, race, sex, and other information. Accordingly, my personal identifying information is contained in the California Department of Justice's automated firearms system. So basically, that's all the information that I'm providing that they have access to. They're giving to universities and third parties. I understand that under Assembly Bill 173, the California Department of Justice is required to share information in the automated firearms system and ammunition purchase records file with the California Firearm Violence Research Center. The California Firearm Violence Research Center, that's not a government entity, and permits the sharing of this information with other institutions for academic and policy research. So this is just a piece of my declaration for summary judgment. We're hoping that we get that summary judgment, that the judge absolutely sees it our way and says, yep, you guys have a case. It's pretty obvious to us. And that we get the privacy. It's one step closer to getting the privacy that we deserve as gun owners. Next case is Snope versus Brown. That's the assault weapons ban case. So we've been talking about this on and off, like every couple of weeks. There's been a little bit of movement. This is certainly an extremely important decision. It's an important case that could lead to an important decision. It's an assault weapon ban case, very similar to California's. It's in Maryland. The Supreme Court has actually, they were supposed to talk about taking the case, but there's a snag. It now has been rescheduled, and there's no additional date. Now, this could mean a lot of things. It could mean anything. It is completely impossible to know what this means for the case. There's a lot of speculation. It could mean that the Supreme Court will definitely take the case. It could mean that they will definitely not take the case. It could mean that they're going to take a case that's similar, but aren't sure if this is the case to take. So, this is part of, we talk about these lawsuits and legislation because you guys are interested. And I think it's interesting to know, but I want to emphasize, I think this is a good opportunity to emphasize that, it's so difficult. There are so many avenues. There are so many timelines. There are so few requirements on judges. They can kind of do anything they want. And there are a bunch of different ways they can do it. So knowing like what the next step is and kind of keeping tabs on each step and here's where it is in the process and it could go here and it could go there. It just doesn't do a whole lot, so you have to be patient, keeping in the loop and knowing what's going on is good, but don't let that be your activism. It's kind of an interesting thing. Oh, okay, here's where that case is, or here's what's going on in that case. But until we get a decision, there's not much for you to do. There's not much. The information is just nice to know. It's not really creating an opportunity for you to be an activist. Last week we talked about SB 15, Senate Bill 15, as introduced by Blake Spear, who's a local anti-gunner. It's the gun violence prevention law, and it's not built out in any way. There's nothing in there. There's still nothing in there. I want to point this out. I want to stay on top of this to make sure everybody knows. This is just a placeholder. They just said, hey, we don't like guns, so we're going to have Senate Bill 15, and eventually we'll tell you what it means. So stay tuned for that. ATF is something else we've been talking about. There's still no decision on the director. Whatever happens, it is my opinion that the ATF needs to be completely and totally dismantled and gotten rid of. So whatever they do under the Trump administration, whatever director they decide on, they need to get as close to completely dismantling the ATF as they can possibly get. There's not one redeeming characteristic of the ATF. And any and all ATF agents should be blacklisted from serving in law enforcement on any level for the rest of their life. It is absolutely a predatory agency. The ATF is absolutely unconstitutional. The activities they've done are, completely wrong. They're a predatory agency. I've seen it firsthand, and I have, very little fear in saying it. So many of the gun laws that they enforce need to just go away, and that's first off. And then second, the idea that any laws that are left won't get enforced if there's no ATF is completely disingenuous and ridiculous. There are plenty of law enforcement professionals and agencies left after ATF has completely gotten rid of that can enforce those laws, that are currently enforcing those laws. So the idea of, criminals are just going to get away with, wreaking havoc. Well, no, that's not what's going to happen. What will happen is if the ATF is gotten rid of or severely restricted, then sane, trained, law-abiding gun owners won't have a predatory federal agency with unlimited funds breathing down their neck. And I truly, truly look forward to the day that happens. The subjective and random nature of the basis of the gun laws that ATF enforces makes the ATF and its $1.6 billion budget, $1.6 billion budget every year, makes them completely useless, completely, in favor of getting rid of them 100%. And then last, before we get to our first guest, which I'm really looking forward to, local John Dillon, who's the sponsor of this segment. Everybody knows John. He's a fantastic Second Amendment attorney. He had a very cool victory that you will not hear about anywhere but here. So let me read you just a piece of it. This was in, oops, that's not it. Give me 2 seconds here to pull it up. Sorry, guys. Stick with me. This was in Superior Court in the state of California. It was right here in San Diego County. It had to do with somebody trying to get a CCW. In fact, it was a couple that was trying to get a CCW, but due to SB2, they were denied, and they were denied for not a very good reason. Give me a second here. Just one piece I just want to read to you.
I'm just guessing as you're searching.
Yeah.
Was it a GVRO?
No. Oh. No, they were just trying to get their CCW. Here it is. This was a perfect part. I got like 100. Let's see. I actually have 63 pages of dialogue here, but this pretty much sums up what people need to know. As the current party is aware, my clients have been. This is John talking. This is him talking to the court. My clients have been denied their CCW application and thus their Second Amendment right to keep and bear arms in public, not because they are prohibited people, not because they have any type of criminal record, not because they have made threats to other individuals, and not because they have made any threats to harm themselves, and not because the sheriff nor the state has provided any evidence of any kind that they have ever been accused of any type of violent or threatening conduct. They are being denied their rights solely because of the subjective opinion that they must be a dangerous person or prone to violence because they are members of a motorcycle club. And in the case of the woman in the couple, she's not even a member of the motorcycle club. She's merely married to a member of the motorcycle club. As well as the underlying penal code section, 26202. So this is why they're being denied. Is penal code section 26202. It's patently, he's describing it as patently unconstitutional under Bruin if an issue before the court is arms-bearing conduct. Under the plain text, the burden immediately shifts to the government to justify that restriction through relevant historical arms regulations. Bruin argued, decided that there is a Second Amendment right to keep and bear arms in public, so the government must justify this restriction in the case. So this was basically SB2. So what happened was, this is a good opportunity to really emphasize that SB2, in effect, took over CCW issuing. The sheriff's still there, but really the sheriff has little latitude to issue or deny. They basically have to follow exactly what SB2 says. It's standardized what's going on. So they have to follow state law. And SB2 basically said, hey, this person is a part of a group. In this case, it's a motorcycle club. The motorcycle club that they go like Toys for Tots. They have spaghetti dinners on Friday. It's not like it's some, criminal, outfit. They decided that, hey, since these people wear a jacket that has this motorcycle club's name on it, then the state of California won't give them a CCW. And so John took that case and won. Said, nope, this is completely and totally subjective. So next part of this will be using this to try to get this completely erased from California's requirements, which is very, very cool. Thank you so much, John. Thank you for continuing to work on this kind of stuff.
That's amazing.
Yeah, right.
So there's so much about as far as restrictions or issues that have come out of SB2 that have attempted to regulate beyond the sensitive spaces, like the GVROs, right? We
Right.
know a number of lawyers and attorneys locally who've been fighting and winning.
Yep.
You know, those who lose their permit because of GVRO,
Yep.
getting those back. That's amazing that, that's the first time I've heard of anybody getting denied based on that since. I imagine there could be others, but I'm not aware of them. So
Yeah, this is the first and only case
This
I've
is
run
all.
across in San Diego so far, and there was, so it's good news.
so we're fighting a good fight.
It's good news, and SB2 is just it was the governor having a hissy fit. It wasn't. It's unconstitutional, and not just the sensitive, the expansion of the ban.
Right.
Where you can carry, which is really what it is. It's a ban on where you can carry. That needs to go away, but above and beyond that, there are little pieces that are completely and totally against Bruin that also need to go away. So we're working on it. So thank you, John. All right.